successor trustee distributes assets to beneficiaries without the need for probate.
Trusts shine for two reasons: probate avoidance and continuity.
For cross-border heirs, if beneficiaries live abroad, trust can specify distribution timing to avoid unexpected tax or immigration.
If a beneficiary receives government benefits, an outright inheritance could disqualify them.
Hello. Today, we're talking about one of the most essential acts of protection you can do for your family, making a revocable living trust. Please note that I am not an attorney, and this is not intended as legal or tax advice. This discussion is intended solely for educational purposes, providing general information about these trusts.
Today we'll demystify revocable living trusts, what they are, how they avoid probate, and when they're a better choice than just a will. We'll show real-life examples, including estate outcomes and special guidance for families on H-1B or green card tracks. A revocable living trust is a legal entity you control while alive. You transfer assets into the trust. You remain trustee during your life. After you die, a successor trustee distributes assets to beneficiaries without court interference. Because the trust owns the assets, those assets bypass probate, which saves time, money, and keeps your affairs private. Key parts: settlor/grantor is you, who creates the trust. Primary trustees manage trust assets during your life. Successor trustees step in after you die or become incapacitated. Beneficiaries are those who receive the trust assets. You keep control. You can change or revoke the trust at any time while competent. Trusts shine for two reasons: probate avoidance and continuity. If you own a house, brokerage accounts, or a business, funding them into a trust means your family avoids the delays and public filings of probate. Creating a trust is only step one. You must fund it. That means change the deed on real estate to the trust, retitle brokerage or bank accounts into the trust name, or add payable on death designations, transfer business interests, or have clear assignment documents. Unfunded trusts are common mistakes. They leave assets exposed to probate. We made a trust, but never updated the house deed. After my spouse died, we still had to go through probate. It felt like planning, but not finishing. That's why you should audit your assets after creating a trust. A checklist helps.
Use a revocable living trust when you own real estate in multiple states, as multi-state property often triggers separate probates. You also use a trust when you want privacy, as trusts avoid public filings, unlike wills. Furthermore, a trust provides a smoother handoff for minor children or family members with special needs. However, a will still matters significantly to name guardians for minors, as a trust cannot appoint a guardian. It also acts as a pour-over will that moves any unfunded assets into the trust when you die. Many families wisely choose to use both, a trust for assets and a will for guardianship and backups. Trusts typically cost more upfront than a simple will, but they often save money and time later. This is especially true for estates that might otherwise face multi-state probate or litigation. Probate can cost anywhere from 3 to 20% of an estate, while trusts often help avoid that range. Peer-reviewed research consistently shows that trusts reduce probate costs and speed up asset distribution in many cases. If you're on an H-1B visa or pursuing a green card, trusts offer special advantages and considerations. Some retirement plans, like Social Security and certain retirement accounts, may not accept trusts as direct beneficiaries without careful drafting. It's crucial to work with legal counsel to preserve all tax benefits in these situations. For cross-border heirs, if beneficiaries live abroad, trust can specify distribution timing to avoid unexpected tax or immigration consequences. Remember, trust cannot name guardians for minors. You still need a will for that vital role. Finally, real estate outside the U.S. might not transfer by a U.S. trust, so coordinate with local counsel in those regions. We were green card applicants with family overseas. A trust let us keep U.S. assets coordinated while we set instructions for international relatives to receive support without court fights.
Your successor trustee should be trustworthy, organized, and ideally local, or a corporate trustee if assets are complex. Ideal qualities include trustworthiness, organizational skills for handling assets worth over $500,000, and proximity, as local trustees avoid travel costs averaging $2,000 to $5,000 for out-of-state trustees. For complex assets like real estate in multiple states, affecting 15% of U.S. households, a corporate trustee like Wells Fargo Trust Services, charging 0.5 to 1.5% annually, is often recommended. Many families name co-trustees, a family member plus a professional. Co-trustees are used in 40% of trusts, balancing emotional and expert input. For immigrant families, comprising 14% of the U.S. population, consider naming a successor who understands both U.S. systems and your family's home country, navigating dual legal systems. Communicate your plan to trustees and beneficiaries to reduce surprise and conflict. Early involvement can reduce conflicts by 50%, as documented in 2020 guidelines from the National Academy of Elder Law Attorneys. If a beneficiary receives government benefits, an outright inheritance could disqualify them. For example, an inheritance over $2,000 can disqualify someone from SSI or Medicaid. This could potentially cost $50,000 or more annually in lost aid. A properly drafted trust, like a special needs trust, can create supplemental needs provisions. These trusts, integrated since the 1993 Omnibus Budget Reconciliation Act, provide supplemental funds for extras like education or therapy without counting as resources, protecting approximately 1.2 million disabled Americans. Work with counsel to draft special needs language and trust protector provisions. These provisions ensure compliance and are overseen by an independent trust protector, appointed in 25% of modern trusts. Up to 60% of revocable living trusts fail due to errors. Avoid these common mistakes. First, not funding the trust. Only 50% of assets are typically transferred, leading to probate delays of 6 to 18 months and costs of $15,000 to $35,000 for a $500,000 estate. Second, forgetting to update beneficiary designations on non-trust assets like IRAs, which hold $6.5 trillion in the U.S. Naming the trust directly can violate IRS rules. Third, choosing an inexperienced successor trustee, which causes 30% of disputes. Vet candidates with background checks costing $100 to $300. Fourth, ignoring tax or retirement account rules. RLTs are grantor trusts, reporting income on Personal Form 1040, and state-specific issues like California's community property rules affect 40% of married couples. Ask yourself, do I own property in other states? Multi-state property, affecting 10% of estates, triggers ancillary probate with extra $5,000 to $10,000 fees. Do I have retirement accounts that require special handling, such as conduit provisions to stretch RMDs over 10 years post-Secure Act 2019? Will any beneficiaries need protected distributions via spendthrift clauses? Imagine your family the day after you're gone. Who will step in? Will they have clear instructions? For H, 1B, or green card holders, how will cross-border issues affect guardianship or distribution? For the 1.1 million H, 1B/green card holders, trusts must address FACA reporting and potential U.S. CITAS asset taxation, which can be up to 40% estate tax. We funded the trust and named a corporate co-trustee. When my partner became ill, the successor trustee handled the bills with no court delay. Revocable trusts aren't magic. They require maintenance and funding. But for many families, they mean fewer delays, less public exposure, and a smoother handoff. Pair a trust with a will. That gives you both asset control and guardian appointments. RLTs with wills cover 80% of estate needs, ensuring smooth handoffs for families.
Do not forget to like and subscribe to our channel for more information on will and revocable living trust. Also, consider attending our online seminars to gain more tailored knowledge on these topics. Details are provided in the description. We look forward to seeing you in our seminars.